If you're tired of these promos, supporters get the podcast early and ad-free. Just go to donate.bogosity.tv for the links to sign up. Welcome to the Bogosity podcast for the week of April 28, 2024, the podcast that hits below the belt. This is your host, Shane Killian. Let's cocainize the news of the bogus. Let's check in on the case we've covered from time to time where publishers who, as we've covered, hate libraries with a passion have been trying to take down the Internet Archive as a bunch of filthy, stinking pirates. After losing basically every other argument against them, they've been focusing on the IA's digital lending library, which works just like a library, only online. They purchase a copy of a book, then they make that book available to lend. While the book is lent out, it's not available for anyone else, just like in a regular library. Unless, of course, the IA buys another copy. They can have as many copies lent out at one time as they have purchased, just the way a normal library works. In 2020, Hachette, HarperCollins, John Wiley, and Penguin Random House sued the IA, saying it was copyright infringement. The federal court actually ruled against the IA and found for the publishers. If you're wondering why, here's a hint. The lawsuit was brought in the Southern District of New York. The same ones who brought you Martha Stewart, Universal v. Corley, the Ross Ulbricht trial, and the latest E. Jean Carroll fiascos. As we've covered over and over again, they've got to be the second most corrupt district next to the D.C. District Court. So the IA appealed to the Second Circuit. They've got filings showing pretty clearly that this is all fair use, and the arguments of the publishers don't hold any water at all. But the publishers are fearing a Napster moment for books, saying that you shouldn't be allowed to digitize books and make a digital lending library without the publishers being involved. Remember what we said about copyrights going all the way back to the Statute of Anne? It's all about the profit of publishers, not the rights of the authors, and certainly not about the reading public or the creative output of humanity. Whereas amicus briefs supporting the IA have come from groups like the Authors Alliance, a group of hundreds of authors who are urging the publishers to drop the case. The court has also accepted amicus briefs from library foundations. Back in December, they submitted a filing claiming fair use, since its lending is limited in an owned-to-loaned ratio. The IA has no profit motive. Libraries have a much broader mission than the publishers claim, including access to a wider range of books, and especially to poor people or people in remote areas who don't have access to a physical library, and that the balancing act courts do with copyrights leans in their favor. The publishers came back with their response, and now the IA has submitted a reply brief, and it's pretty epic. The publishers painted a doomsday scenario if the court ruled in favor of IA, and the IA pointed out that, because of the huge investment and lack of profit such a venture entails, fair use would never trigger such a scenario. They also basically ignored every other reason why the IA exists. Quote, IA's lending serves additional transformative purposes by enabling innovative interactions between books and the Internet, such as site-checking online resources like Wikipedia. Publishers dismiss this feature as unimportant because they claim it is not IA's library's main purpose. But works rarely have one purpose, so courts don't ask whether the new product's only purpose is transformative, but whether a transformative use may reasonably be perceived. As for their claims of lost licensing fees, quote, publishers do not describe any market for controlled digital lending or claim any intent to develop one. Publishers cannot demonstrate a profitable market based on IA's nonprofit use and assert no intent to pursue a market licensing controlled digital lending. Instead, publishers concede they simply want to preclude controlled digital lending altogether. They show quite clearly that the publishers have shown no market harm whatsoever from IA's lending library. And then there are the benefits of the service. Quote, contrary to publishers' assertion, IA explained how its lending benefited the public and provided numerous concrete examples. Publishers cannot claim that they alone created those benefits because the students, researchers, and authors who used the works for education, research, and scholarship would not have reasonably been able to access the books without IA's lending. They concluded, publishers' argument that terminating only open libraries would not make a difference to the fair use analysis is refuted by their own brief. Their arguments rely substantially on IA's overlap analysis and potential for growing partnership with other libraries. Further, the record does not support publishers' assumption that controlled digital lending of only IA's own books would allow for substantially increased lending. IA has limited copies of each book, sometimes only one, so multiple libraries cannot rely on IA's website to meet their patrons' needs. And even putting aside book buying expenses, storing them and operating the associated digital infrastructure costs millions of dollars, limiting the number of books and concurrent borrows IA can offer on its own. Here's hoping the Second Circuit is less corrupt than the SDNY, which, it's a pretty low bar. If you're looking for a way to support this channel, but you don't have any spare cash and you can't stand ads, you can do so by generating your own cryptocurrency. Use the links at the bottom of the description to follow the link to Odyssey.com to listen to the podcast and see all of my YouTube videos as well. Just watching videos will produce cryptocurrency for the creator and yourself. And since Odyssey is always monetized and never censored, you'll have no problem seeing all the videos from your favorite creators. You can also use the library credits you created Odyssey to tip creators and even purchase paid content. Earn library credits through various rewards, including daily view rewards and the number of shares and invites. And you can interact with creators in all sorts of ways, including like and dislike, comment, boost a post by supporting it, repost it, and share to other sites, all while earning crypto for the creator. Easily monetize yourself and your favorite creators using cryptocurrency, without advertising. Use the link below to visit this channel on Odyssey.com and see many of your other favorites there as well. Another one we've covered is Backpage, the classified advertising service similar to Craigslist that was shut down because it facilitated prostitution. They were able to shut down the site even before the passage of Sesta Fosta. Numerous investigators, both federal and state, made claims that ended up being backed up by a GAO report that this had an adverse effect on law enforcement. Since Backpage worked with law enforcement to track down any actual sex trafficking victims and their perpetrators on the site, the ability of law enforcement to enforce those dramatically decreased after the site was taken down. It's a lot harder to do that with overseas websites or operations that take place entirely in meat space. So, yeah, way to go, guys. Thanks for helping. We covered how federal judge Susan Brnovich declared a mistrial in the case because the prosecutors just couldn't stop talking about child sex trafficking in a case where there was no such charge. Of course, she was in the District of Arizona, not the Southern District of New York, so she couldn't or wouldn't pull a Catherine Forrest and let the claims in anyway like that judge did with Ross Ulbricht. Since then, Brnovich's husband became Attorney General, and she recused herself due to the conflict, so Diane Humatewa took over the case. Last fall, a jury found Michael Lacey guilty of just one of the 86 counts against him, a money laundering charge, and not guilty of the other money laundering charge. They hung on the other 84 counts, including charges that he facilitated prostitution. His co-founder, James Larkin, committed self-deletion just days before the trial. Now, Humatewa has acquitted Lacey on 53 of the remaining counts. She also acquitted Scott Speer, former executive vice president of Backpage, on 10 of the counts on which he was found guilty, and CFO Jed Brunst on 18 counts. 2 other defendants were completely acquitted on all charges by the jury. By the way, you should know by now how to react to these huge count numbers. Each entry on the website, each transaction, each money transfer, every last little thing that happens ends up being a separate count. So things that reasonable people would consider to be a single act can be conflated to 10 or more. Prosecutors do this pile-on all the time. Some of the remaining charges are pretty serious, but most of them are possible 20-year sentences for money laundering. Lacey said he will appeal his conviction on the grounds that the money they claim he concealed was reported to the federal government with all the proper paperwork. For a website that did nothing wrong and continually did the right thing by working with law enforcement when users of their site did something wrong, the oppression and persecution of the site operators continues long after the case has fallen out of the public memory. Especially since there is no ethical justification for laws banning prostitution, and trafficking is such a broad term that's been applied to so many varied activities that it should be completely voided for vagueness. And even if they are exonerated, there's all the damage the process has done to them, including the self-exit of their friend, and that's not including the permanent damage to their reputations and relationships. Always keep that in mind. The far-reaching consequences of the things the news media gets you so riled up on.
If you're on the Wi-Fi in a coffee shop or hotel, anyone on that network can get your traffic. Do you really trust all of those strangers? For that matter, do you really trust your ISP? A VPN can protect you from prying eyes, disguise your location, and even foil government censors. It's essential in this day and age, so go to vpn.bogosity.tv and you'll be taken to BoxPN. Starting at just $2.99 a month, you can get unlimited high-speed connections to VPN servers all over the world, and they don't log connections, so your privacy is assured. Traveling abroad, just VPN home, and don't worry about what those other governments are doing. Back at home, stop your ISP from traffic shaping and messing with the quality internet access you're paying good money for. You can connect from multiple machines at once, including your smartphone or tablet, and it supports all the secure standards, including OpenVPN and SSTP. Bypass censors and surveillance with your own secure VPN connection. Go to vpn.bogosity.tv.
The Supreme Court heard oral arguments in a case you might not have heard of, and sadly has been ignored in the wake of more high-profile cases such as presidential immunity. This one is the City of Grants Pass, Oregon v. Gloria Johnson, and it has to do with some of the things cities do to stop homeless people having a place to sleep. But its implications are much more far-reaching than just the homeless and can affect basic due process rights for you and me. So, this'll be another long one. For those of you who like my commentaries on the Supreme Court oral arguments, strap in. If you don't, just look at the time codes in the description and skip to the next story. Really, you won't hurt my feelings. If it helps, this is the last week of Supreme Court oral arguments for this session, so it's the last you'll have to put up with from me for a while. The Ninth Circuit held that camping laws stopping the homeless from sleeping on public property violated the Eighth Amendment. Everyone's talking about this case in terms of what it means for the homeless, but like so many others, it has much broader consequences for all of us. It criminalizes people who are involuntarily homeless, basically making it a crime for them to exist. So the Oregon Law Center filed a class action suit on behalf of Deborah Blake, who at the time had been homeless in Grants Pass for up to a decade and had numerous fines and criminal penalties levied against her, despite the fact that it was demonstrated that there was no shelter available with space to take her in. After Blake died, Gloria Johnson was assigned as class representative. This case is about the Eighth Amendment's prohibition on cruel and unusual punishment. In 1962 in Robinson v. California, the Supreme Court held that the Eighth Amendment prohibited criminalization of a status as opposed to criminal acts, particularly if the person has that status involuntarily, as was the case with both Blake and Johnson. The state is arguing that this restriction never applies to cities and states. The state is arguing that this restriction, this basic protection of the Eighth Amendment, never applies to cities and states. They want to be able to criminalize whatever they want, whenever they want, and not have to pass constitutional scrutiny. Just take a listen.
The Cruel and Unusual Punishments Clause governs which punishments are permitted, not what conduct can be prohibited.
Wow. Just stop and think about what that means. The Eighth Amendment is supposed to mean that the punishments fit the crime. You don't give someone the death penalty for jaywalking. But they want to remove the conduct entirely and make it just about the punishment, regardless of how it relates to the conduct.
The Ninth Circuit's approach has proven unworkable. The Eighth Amendment does not tell courts who is involuntarily homeless, what shelter is adequate, or what time, place, and manner regulations are allowed. But in 35 suits and counting, federal courts are now deciding everything from the exact size of campsites in San Rafael to the adequacy of empty beds at specific shelters, like the Gospel Rescue Mission in Grants Pass. And cities are struggling to apply arbitrary, shifting standards in the field.
Yeah, but turns out that matters.
Unfortunately, beds are going unused at the Gospel Rescue Mission. People are not getting the help that they need. The city is under an injunction here, and it's unable to rely on these basic ordinances.
And very unusually, right off the bat, it's Sotomayor who comes out and mentions the very obvious problem with that.
The Gospel unused beds, they're less than 100, right?
That's correct.
And there's thousands of homeless.
There are, I believe, as many as 600 in Grants Pass, according to the district court.
But there's still only less than 100 beds.
That is right.
So, yes, they are criminalizing a status. Someone being homeless, but not having any shelter to go to because there aren't enough beds for them. She goes on arguing the problem of the homeless and makes some good arguments, but doesn't really hit the major problem with the Eighth Amendment violation here. But Kagan gets to the status issue.
So taking Robinson as a given, could you criminalize the status of homelessness?
Well, I have a couple points to that.
It's just a simple question.
So Robinson doesn't address that, and I think it's completely distinguishable. So Robinson was...
Could you criminalize the status of homelessness?
Well, I don't think that homelessness is a status like drug addiction, and Robinson only stands for that.
Well, homelessness is a status. It's the status of not having a home.
I disagree with that, Justice Kagan, because it is so fluid, it's so different.
Yeah, notice how she really, really doesn't want to answer that question. And even after going on for another couple of minutes...
I mean, that's quite striking.
No, I don't.
That you think that you can criminalize just homelessness.
No, we're not saying that homelessness is a status, but most importantly, I think the Eighth Amendment is the wrong way to focus on this question.
It's really a simple question. Can you criminalize homelessness? And you are suggesting, yes, you could.
No, we do not criminalize homelessness. I'm not saying...
Could you criminalize homelessness? Not tell me what you do, what you don't do. Could you?
And she never answered the question.
And when you started off here today, you said we're just criminalizing conduct. So to tell you the truth, I thought that this was going to be a question where you would say, no, of course we can't criminalize a status, but there's conduct here. And then I was going to say, what is the conduct here? But you didn't say that. You said you could criminalize even the status of homelessness. And that suggests to me that you're off on the wrong track in thinking about this issue.
To say the least. Jackson also got some good comments in. I won't play them, but you could really hear her history as a defense attorney coming through. The three institutionalist justices, Barrett, Kagan, and Roberts, were actually pretty useless here, just asking about technical procedural stuff. The real question is, how are the conservatives going to react, given that they've never been that great on Eighth Amendment issues? One basis of comparison, because this was the subject of the Robinson precedent, was someone who was doing drugs not out of free choice, but by the compulsion of addiction.
Compare that with a person who absolutely has no place to sleep in a particular jurisdiction. Does that person have any alternative other than sleeping outside?
So I think we'd have to ask all of the questions I mentioned earlier about what alternatives they might have had yesterday.
No, they have none. They
there.
have absolutely none. There's not a single place where they can sleep.
If that's true, then that may be the case. And in that case, at least in Oregon, they would have a defense of necessity.
Okay, that's something, I guess. Thanks, Alito. Thomas and Gorsuch didn't have much to say either, at least not until the opposing party got up.
Mr. Needler, wouldn't you have a better argument if Robinson involved someone being arrested for using drugs, but then the court said that you were, in effect, arresting him for the status of a drug user because he had no choice but to use drugs because he's an addict?
No, our position is not that the conduct, as in Robinson, the drug addict can't stop from using drugs. That is not our position. That's a question of personal culpability on the basis of what.
So what's the difference between that and camping out? What you're saying here, it seems as though you're saying, well, there's no other choice, so you have to camp out. Therefore, you're really arresting this person for the status of homelessness.
Yes, but not because of an involuntary compulsion sense. I think, as Justice Alito pointed out, the nexus here is actually closer than in the addiction situation, because sleeping outside is essentially the mirror image of the other side of the coin, or the definition of the status of homelessness.
Mr. Needler, I agree that the distinction between status and conduct is a slippery one, and that they're often closely related.
The point here, it is the government that is prohibiting the alternative. It's not the individual's inability to control his own conduct. The government, because of other circumstances, the lack of money, the lack of a friend to stay with, the lack of shelter space, there is no place. We take as a given in our position that there is no other place for the person to sleep.
Couldn't a drug addict, though, make the exact same argument? I had no other choice.
Yeah, they just don't seem to get it. It's not a compulsive act like drinking to an alcoholic. It's the crime of simply existing. You must exist somewhere. And if you have nowhere else to go, you grab a blanket and sleep in the street. Punishing someone for something that is involuntary, something not within their control at all, has, since our very founding, been considered cruel and unusual punishment, no matter how minimal it is. Roberts, have you got anything good to contribute?
So if someone is hungry and no one is giving him food, can you prosecute him if he breaks into a store to get something to eat?
Guess not. Alito?
What if the person says, I know there's a bed available at the Gospel Rescue Mission, but they won't take my dog?
Oh, for the love of Mike.
Yeah, I don't think the inability to take your dog to the shelter is a sufficient reason. There are shelters in some larger cities that may well take pets, but
I know I could sleep in the home of a family member, but they really hate me and they're really nasty to me. I'm wondering how this is going to be administered on a daily basis.
And I think, with all respect, I think that example is if the family is going to accept him, but that's the question, whether there is a place to sleep. And I don't know that it would very often come down to that family hates me. On the other hand, if it's a woman who left domestic abuse, she couldn't be expected to go back to her home, or maybe her relative's home, or his relative's home, or something. So there's a lot of common sense.
That's the point. If the person has nowhere else to go, how is being there a crime? All right, then. Gorsuch?
What about someone who has a mental health problem that prohibits them? They cannot sleep in a shelter. Are they allowed to sleep outside or not? Is that status or conduct that's regulable?
I think the question would be whether that shelter is available.
It's available.
Well, no, available to the individual.
It's available to the individual.
You just said it wasn't, you moron!
It's just because of their mental health problem, they cannot do it.
I think there might be, that's the mental health
status
problem.
Or conduct.
Well, the mental health situation is itself a status.
Right, I know that.
Well, apparently you don't. You just made a hypothetical where he couldn't sleep there because of his mental health status. So how have you not answered your own question? Gorsuch just went on like this for a while with various different hypotheticals and just didn't get the point. If you're not allowed into the shelter for whatever reason, you have to sleep somewhere. And that's when they arrest you, simply for the crime of existing. I swear, when the conservative justices get to the higher numbered amendments in the Bill of Rights, they just forget everything. Here's what it's really about. If the 8th Amendment applies, they don't get to control the homeless anymore. It's about bureaucrats, social workers having control over the homeless and where they can go and what they can do. And they also, as we've covered so many times before on this podcast, want to get the homeless out of the public eye so they can pretend it's not a problem in their city. Because every homeless person on the street is a testament to their failure. And in the process, they'll eviscerate what the 8th Amendment is all about, protecting you from ridiculous crimes and punishments that go way beyond any acts you've committed, especially when those acts are involuntary and even when it's as simple an act as existing. The conservatives and institutionalists just couldn't bring themselves to consider the question. If a person doesn't have anywhere to sleep and doesn't have access to a shelter, what are they supposed to do? This is one where the liberal justices seem to be good, but I can't get a beat on the rest. They need to convince 2 others that this is a violation, which I'm not sure about, and then they'd have to write a good opinion showing why this would be such a horrible evisceration of the 8th Amendment, which I'm even less sure about.
Do you have children, or nieces or nephews? Are you homeschooling, or just want to counter some of the socialist indoctrination most children get in school? If so, go to Bogosity.tv/TuttleTwins, and you'll be taken to a website where you can get some great books for elementary-age children. The Tuttle Twins books are books about liberty and free market economics that include children's versions of Bastiat's The Law, Leonard Read's I, Pencil, and Hayek's The Road to Serfdom, as well as books about the Federal Reserve and how regulations protect business cronies. They'll learn about the harm caused by eminent domain, or regulations passed in the name of safety, and fundamental concepts of liberty. And as you can see from the sample pages on the website, they're all easy to read and nicely illustrated. They're just $9.99 a piece, or get a special discount as well as free bonuses when you purchase all 5. You can even buy in bulk to donate to schools and local libraries. So get the Tuttle Twins books at Bogosity.tv/TuttleTwins.
And now it's time to de-differentiate this week's biggest Bogon emitter. And this one goes to Universal Music Group for more copyright shenanigans. As we all know, they hate creativity, especially when it's making fun of one of their artists. Case in point, Dustin Ballard, who makes parody songs and who put up a disclaimer on his latest YouTube video on his channel called There I Ruined It, where he does things like have Simon and Garfunkel sing Baby Got Back, or Celine Dion singing in all 12 keys at the same time. That latter one sounds like an evil cat demon scraping its claws on a chalkboard. In other words, slightly better than Dion herself. This one is about his video where the Beach Boys sing Jay-Z's 99 Problems, which he made sound like their song I Get Around. The video started off with a long and convoluted text crawl explaining how parody is fair use, protected by both the First Amendment and Section 107 of the Copyright Act. UMG, since they hate fun, stepped in and had the video taken down via copyright action. It's unknown whether it was a DMCA takedown or just Content ID, but either way, as big as they are, and with their legions of lawyers, they know perfectly well that they need to take fair use into account when taking such actions. And I also don't accept the possibility that it might have been automated as an excuse. As sophisticated as their models are, they can tell the difference. In fact, they lost a pretty big lawsuit over exactly that. Lentz v. Universal, the old dancing baby case, where an en banc panel of the Ninth Circuit overturned their previous decisions to make it clear that companies must consider fair use before taking copyright action. But the sad fact of the matter is, YouTube absolutely needs to keep UMG happy to keep existing. So long as the courts are going to continue to be wussy milquetoasts about it, copyright is still going to be a very powerful tool of censorship against criticism and parody. None of the arguments for copyright protection apply here. It didn't make the Beach Boys or Jay-Z or UMG lose any money, nor did it directly compete with people trying to hear 99 Problems or I Get Around. One of the excuses for how copyright protection isn't a blatant First Amendment violation is fair use, but this is just one in a long line of cases, and every YouTuber has stories to tell about this when someone had their parody or criticism taken down by a copyright action from the rights holder. Copyright has long outlived its usefulness. It clearly isn't a tool for creativity, just a way for publishers to keep profiting off the same old regurgitated content while artists get crapped on and independent voices get suppressed. At the very least, there needs to be disincentives from false copyright action against non-infringing uses, including countersuits, reverse monetization, and even perjury charges. But until there's someone on the side of free speech that's as big as UMG, that's not likely to happen. So, as it is, they'll continue to use the shotgun approach, not caring how many legitimate creators they take down in their attempts to get the pirates. Blackstone's ratio on its head. So all of that makes UMG this week's biggest Bogon emitter.
I want to tell you about the eyeglasses I've been wearing for years. As people can see on my videos, I have a very strong prescription, which makes glasses more expensive, especially when I need computer glasses, reading glasses, prescription sunglasses, and most expensively, progressive lenses for general everyday wear. To save money while still getting quality glasses, I get them from Firmoo. In fact, I just got a pair of progressives with high-index aspherical lenses and a nice pair of frames my wife loves for just over $100. It would have been $500 to get them through my eye doctor. Not only do they look good, the glasses are durable. I've worn many pairs for several years without problems. All orders come with a 30-day return policy, a 3-month warranty, and one-on-one customer service. Go to Firmoo, that's FIRMOO.Bogosity.tv anytime you need quality glasses at a low price. Once again, that's Firmoo.Bogosity.tv.
And now let's thermoregulate this week's
Idiot Extraordinaire.
Without a doubt, Donald Trump is the most hated man on the left, so if you prosecute Trump, they're going to cheer you on. So how badly do you have to screw it up for people on the left to turn against you? How about if you're Alvin Bragg and your case is so bad there's even a New York Times op-ed attacking it? Jed Handelsman Sugarman of the Boston University School of Law has a pretty scathing review of the Stormy Daniels hush money trial. He was initially critical of the case, calling it an embarrassment, but now that he's heard the prosecution's theory of the case, he's upgraded it to historic mistake. Quote, "Their vague allegation about a criminal scheme to corrupt the 2016 presidential election has me more concerned than ever about their unprecedented use of state law and their persistent avoidance of specifying an election crime or a valid theory of fraud." Remember, everything Trump is accused of doing, from sleeping with Daniels, to paying her hush money, to paying Michael Cohen to cover it up, to writing the payoffs down as legal expenses, is only illegal if it's done in furtherance of another crime. And the question has always been, what is that other crime? Bragg doesn't have one, just weak inferences of election interference, or, to quote Judge Juan Merchan, to conceal an agreement with others to unlawfully influence the 2016 election. Prosecutor Matthew Coangelo told the jury, quote, "It was election fraud, pure and simple." But as Sugarman points out, quote, "As a reality check, it is legal for a candidate to pay for a non-disclosure agreement. Hush money is unseemly, but it is legal. None of the relevant state or federal statutes refer to filing violations as fraud. Calling it election fraud is a legal and strategic mistake, exaggerating the case and setting up the jury with high expectations that the prosecutors cannot meet." I guess Bragg is thinking that the biased Manhattan jury will just convict Trump if you give them an excuse, and election interference is as good a one as any. Sugarman isn't so sure. First off, there's nothing in the Federal Election Campaign Act making this a crime. Second, this is a New York State criminal court, so the predicate offense must also be a New York crime. And he writes, 8 years after the alleged crime itself, it is reasonable to ask if this is more about Manhattan politics than New York law. This case should serve as a cautionary tale about broader prosecutorial abuses in America and promote bipartisan reforms of our partisan prosecutorial system. So it's not even clear if Bragg will prevail at the trial court level, let alone after it's over and Trump appeals in state or even federal appeals court. Quote, "This case is still an embarrassment of prosecutorial ethics and apparent selective prosecution. Nevertheless, each side should have its day in court. If convicted, Mr. Trump can fight many other days and perhaps win in appellate courts. But if Monday's opening is a preview of exaggerated allegations, imprecise legal theories, and persistently unaddressed problems, the prosecutors might not win a conviction at all." Meanwhile, Trump, forced to attend the trial to keep him from campaigning in swing states, has decided instead to just campaign in New York. And, oddly, he's attracted crowds that before wouldn't have been so keen on him. Case in point, Bobby Bartels, leader of Steamfitters Local 638, who says most of his union workers are Democrat, but they'll be voting Trump in 2024. Listen to what he said to a Newsmax reporter.
In the past, we are basically Democrats, all of us, and after what's happened the last 4 years in this country, Democrats are basically pushing everybody to the other side. We're a very patriotic group, and we love our country, and we want the best for America. We are tired of immigration. We're tired of our tax dollars going to immigration. We're tired of the crime. We need to put a handle on things in this country and bring it back to how it should be.
And here's what he told a Fox News reporter.
I put out a poll in my union. President Trump is leading Joe Biden 3-1 on my presidential poll out of my 9,000 members right now. We are very tired of the situation with groceries, inflation, gas prices, illegal immigration, crime. We're living it every day in New York City.
And apparently, they're not the only ones. Uncharacteristically for a Manhattan audience, when Trump spoke, he was greeted to cheers and supportive chants. Trump has said he's, quote, going to run very hard in New York. And that might not be the fool's errand you think it is, although New York is considered a safe blue state, and in 2020 he lost the state with 37% to Joe Biden's 60%. If you look at a heat map of the state, most of the blue voters are concentrated in New York City, Albany, Ithaca, and to a lesser extent Syracuse. But very near to the trial court, you have conservative Richmond County, as well as most of Long Island. Suffolk County is fairly red, and Nassau County, while blue, was close in 2020. Biden won the state mostly because of coastal upstate counties, which were very close. In particular, Essex, Saratoga, Broome, and Clinton counties might be ripe for a switch. If he turns those blue counties red and increases the turnout in other red counties, New York might just be a state to watch. And while they're understandably concerned about the economy and other issues, Trump got just as many cheers when he called the Bragg prosecution a witch hunt. Combine that with Biden's plummeting popularity, with an approval rating less than 39%, the lowest of any president in his 13th quarter since and including Eisenhower, and in New York State it's 43% with 49% disapproving, the state may be a lot closer than you think. So if Bragg's prosecution figures into these sentiments and Trump is campaigning more in New York because he's forced to be there, this whole trial just might end up having the opposite effect of the one Bragg and his handlers in the state and the Biden administration intended. And that just has to make Alvin Bragg this week's
Idiot Extraordinaire.
Well, that wraps up this wibbly-wobbly edition of the Bogosity podcast. I hope you enjoyed it. If you did, please go to donate.bogosity.tv for several ways to support, and discord.bogosity.tv to join the discussion. Subscribe at Patreon or Subscribestar, and you can listen early and ad-free. Thank you for listening. Until next time, here's a quote from Lysander Spooner. Those who are capable of tyranny are capable of perjury to sustain it. The Bogosity podcast is licensed under Creative Commons Attribution Non-Commercial No Derivatives 4.0 International License.
Bogosity.